Hello everybody, I'm Tessa Shepperson of Landlord Law and the Landlord Law blog, and I'm here with my assistant Mark to answer your questions. So Mark, what is our question for this week?
So today we've got a question from Jared, who is a landlord, and the question is this: my tenant won't let me enter the property to do a gas safety check. Does this mean I won't be able to use a Section 21 possession notice at a later date?
Yeah, it's crazy actually, but a lot of landlords do have this problem. Quite why tenants won't let the landlords in to do the gas safety check, I don't know, because it's for their benefit. I mean, presumably if you're a tenant living in a property, you don't want there to be a gas leak, because gas is a killer. There are quite a few tenants who have actually become very ill, or some have sadly died due to problems with gas. So if you're a tenant watching this, it's really, really important that you let your landlord in to do these checks, because it's first of all, the landlord is obligated to do it. It's a legal requirement, and secondly, it's for your safety. Now, just talking generally about the gas regulations, first of all, when a tenant first goes in, a landlord is supposed to have already done a gas safety check, and when you do a gas safety check, which needs to be done by a gas engineer which is registered with the Gas Safe Register, they will, once they've done the inspection, and if they say there's any work that needs to be done, you have to do it, and you have to pay for it for your landlord as well, then they will give you a certificate. When your tenant moves into the property, you should by then have given them a copy of the certificate. So before the tenant moves in, you should have given them the gas safety certificate for that property, which was in respect of an inspection that was done within the past 12 months. Now, that's where it connects up with Section 21, because I think it was in the Deregulation Act 2015, it brought in the requirement that to be entitled to serve a Section 21 notice, you must have complied with the gas regulations, and you must have served the notice before the tenant moves in. Now, there have been problems with this, and a lot of landlords haven't realised that they needed to, that being able to serve a Section 21 notice was conditional upon serving the gas safety certificate before the tenants moved in. And those landlords have found that they have problems if they need to evict the tenant. I should say here that if you rented the property to the tenant before 2015 and the tenancy has not been renewed since then, the rule connecting the service of the gas safety certificate with Section 21 doesn't actually apply to you, and there has been a case on that recently. But if the tenancy is started after, or has been renewed after the 1st of October 2015, then this rule does apply. Now, there has been a case on that. In fact, there's been a couple of cases, and we'll put some links in the blog to the reports on the blog that we did on that. And one of the cases is known as the Tricaro case. Have you got the title of the case there? I can never remember.
No, I do not.
Okay, well, it's the Tricaro case. Anyway, we'll put a link on the page. And in that case, it went to the Court of Appeal, I think, and the Court of Appeal said basically that provided the landlord had actually had the check carried out before the tenant moved in, the landlord could rectify the position by serving the notice late. But if the landlord had not had the check done at all, so at the time the tenant moved in there was no gas safety certificate, then basically you're stuffed. I mean, landlords should do the gas safety checks. I mean, these regulations have been around since 1998, you know, they're not exactly new. Now, we do have, which we will link to, I did do an interview with one of the barristers in the Tricaro case, a barrister called Justin Bates, who explained that. If you're interested in that, I would suggest that you watch that. It's a very interesting webinar. The Tricaro case is going to be appealed to the Supreme Court, So we don't quite know what's going to happen. But at the moment, the law is as decided by the Court of Appeal. So that's dealing with the part of this question that's about the connection between gas safety and Section 21. Now, so far as Jared is concerned, his tenant has been there for a while. We don't know how long that was. We don't know whether he served the notice before they moved in or not. That's not information that we've given. But Jared, you know, if you didn't serve it, you're in difficulties. But if he did serve the notice, and you have to do a new gas safety inspection every year, every 12 months, and then you have to serve the notice on the tenants. If a subsequent gas safety inspection, the tenants won't let you in. This isn't going to stop you using Section 21. Provided you'd served the certificate on the tenants when they moved in, or before they moved in. If you're not able to do one after that, that's not going to invalidate any Section 21 notices that you serve. In fact, it would be wrong if that was the case, because it would be quite self-serving, because tenants would be able to prevent their landlords from evicting them by not letting them in to do the check. Now, but you still are supposed to do it. It's a legal obligation on landlords. Now, if your tenant won't let you in, which, as I said at the start, is a pretty bizarre thing for tenants to do, but many of them don't, you are technically in default of the regulations. Now, the gas safety regulations are regulated by the Health and Safety Executive, and they have a rule that if you try to do the inspection 3 times, if you've got 3 documented attempts to do the gas safety inspection, the tenant won't let you in, then that's fine. They are not going to prosecute you. So, for example, you could send them a letter saying, you know, my gas safety inspector will be coming to do the inspection, please let them in, and then if they don't let them in, you could do them another letter saying we're disappointed that you wouldn't let my inspector in, can you contact me so we can arrange a time? And then if they don't respond to that, then you do another letter, you know, sort of saying how it's for their safety and telling them that it's a legal obligation on you. You know, it's not you just being nosy and going around there, you know, it's something that you're supposed to do. If you've got 3 documented attempts, then you're not going to be prosecuted by the Health and Safety Executive. However, long term, it's not a good idea to leave having the gas safety certificate, because gas can be very dangerous, and you know you don't know, there may be a problem with the appliance. I mean, it could blow up the whole house, could blow up the whole street. You know, I mean, so if you are really concerned, if you've got reason to believe that there is a problem and the tenants aren't letting you in, you can go to court and get an injunction ordering the tenant to let you in. This is often done a lot by social landlords, and they're called gas injunctions. And the judge will 99 out of 100 times, probably 100 out of 100 times, will grant the injunction, because it's for the safety not only of the tenant, but the neighbours and everybody else in the street. So you can do that. But provided you've tried 3 times, you are reasonably safe from prosecution. So basically, to answer your question, Jared, you will be able to use Section 21, provided you served the certificate on the original certificate on the tenant when they first moved in. Okay, have I covered everything?
I believe so.
Okay then.
Yeah.
Right, thank you very much. Thank you for watching.